and welcome to our session concerning Bill 60, the Integrated Community Health Services Centers Act 2023. My name is Christine Elliott. I'm counsel here at Fasken, and I'm going to serve as the moderator for today's session. Several of my colleagues who practice in the area of health law at Fasken will also be presenting today. Lynne Golding, Laurie Turner, Sophie MacRae, and Lennie Lejasisaks will all be presenting. They will be covering aspects of Bill 60, known to most of us as Your Health Act 2023, which we expect will be relevant to many of you as you contemplate submitting an application for a license in the future. Following the presentations by my colleagues, we will be happy to receive your questions. We'll do our best to answer all of the questions that you may pose during the time presented, but we certainly can ask questions via the Q&A located on the right side of your screen, and we'll try to get to as many of them as we can. So let's get started. Since I do have a recollection of what happened during the pandemic that led to the long wait lists for surgeries and procedures in Ontario, I thought I would start just with a brief history. We're all aware that it was necessary on 3 occasions within the last several years to put a hold on non-emergency surgeries and procedures in order to provide hospital space for COVID patients. This, of course, led to a longer wait list for surgeries and procedures, some of which had longer than clinically acceptable wait times. It should be noted, however, that the wait list did not start with the pandemic. Normally, there are approximately 200,000 people on the wait list. Not that that's acceptable, but that is the reality. So any review of wait lists should therefore commence with this knowledge. In any event, non-emergency surgeries and procedures, curiously called elective procedures, were first placed on hold in March 2020, shortly after COVID first reached Ontario. By May 2020, these surgeries and procedures were allowed to resume. In September 2020, knowing that the wait lists were growing, the government dedicated $283 million for additional surgeries and procedures, many during weekends and evenings, to reduce the backlog. An additional $457.5 million was advanced to increase community capacity, including home and community care. Increases in COVID numbers and hospitalizations led to another hold being placed on non-emergency surgeries in April 2021, which was rescinded in May 2021. Ontario's Comprehensive Surgical Recovery Plan was released on July 28, 2021, with the increasing number of people on wait lists needing to be served. $324 million was dedicated to allow 67,000 additional surgeries and 135,000 more diagnostic imaging hours. This was intended to allow hospitals to operate at 110 to 115% capacity. The plan also included a $30 million surgical innovation fund, which would allow hospitals to develop their own innovations to increase surgeries. A number of interesting, realistic, and useful options were brought forward and were funded. Finally, some of the funds were used for the development of regional surgical wait lists to ensure that every surgical facility in Ontario could be put to maximum use. In January 2022, due to the highly contagious Omicron variant, cases and numbers increased significantly in Ontario, and once again, non-emergency surgeries and procedures were placed on hold. By early February, case numbers had started to decline, and discussions commenced about lifting this phase 1 of Directive 2 in order to allow hospitals to resume surgeries. On February 10th, 2022, hospitals that had stable numbers of COVID patients and were still able to accept transfers were allowed to move to phase 2, which would allow them to resume surgeries and procedures up to 70% of their volumes in 2019. Phase 3 would later allow them to resume surgeries and procedures up to 90% of their 2019 volumes, while Phase 4 was the full recovery stage. As of this date, there were 250,000 people on surgical wait lists, while there would normally be 200,000, as I mentioned earlier. The missing patient issue was also a big concern. These would be patients who needed to go back to their family physicians for examination and diagnostic procedures. And it was certainly recognized that this could significantly increase the waitlist numbers in the future. An additional $300 million was designated to increase surgeries and procedures even more in 2022-2023. But despite the hundreds of millions of dollars invested in hospitals and community care to reduce the backlog, by January 2023, there were still 206,000 people on wait lists for surgeries or diagnostic imaging. So in February 2023, the government released a report entitled Your Health, a plan for connected and convenient care, which stated an intent to expand the delivery of OHIP-funded surgeries and diagnostic imaging that could be performed outside of hospitals. Bill 60, the Your Health Act 2023, was introduced on February 21st, which was aimed at reducing wait times for surgeries and diagnostic procedures by expanding the number of clinics that can perform these services in the community, and to enable new as-of-right rules, which automatically recognize the credentials of healthcare workers registered in other provinces and territories, so they can start practicing immediately without having to wait to complete registration with the applicable regulatory college in Ontario. Bill 60 proposes to repeal the Independent Health Facilities Act 1990 and replace it with the Integrated Community Health Services Centers Act 2023. In addition to shortening wait times, providing these publicly funded surgeries through clinics will allow hospitals to focus their efforts and resources on more complex and high-risk surgeries. It will also make it easier for Ontarians to access minimally invasive surgeries and procedures, such as cataract surgeries, colonoscopies and endoscopies, hip and knee surgeries, as well as MRI and CT scans. This will first be addressed by tackling the existing backlog for cataract surgeries by issuing 4 new licenses to clinics in Windsor, Kitchener-Waterloo, and Ottawa to support an additional 14,000 surgeries. If Bill 60 passes, the government will allow existing clinics to conduct additional MRI and CT scans. Starting in 2024, the government will expand surgeries for hips and knees. With respect to investment, more than $18 million will be advanced to expand existing clinics, but it's unclear at this time how much is going to be advanced for new clinics. Now, before I ask my colleagues to speak about the details of Bill 60, I would like to speak very briefly about the powers of the Minister of Health contained therein. There are several sections of the bill that speaks to the minister's powers. Section 5 sub 1 states that minister may at any time authorize the director to call for one or more applications for the establishment and operation of one or more integrated community health services centers by sending a call for applications to one or more specified persons, or publishing a call for applications in any manner the director deems appropriate. The minister may also direct the director not to issue a license or licenses in respect of a previously made call for applications pursuant to Section 7 sub 1. Section 18 sub 1 states that the minister may direct the director to revoke or refuse to renew a license or amend the limitations and conditions of a license to eliminate a service from the list of services in respect of which the Integrated Community Health Services Center is licensed. So as you can tell, these sections give significant powers to the minister with respect to granting, revoking, and changing the provisions of licenses. With respect to financing, Section 29 sub 1 states the minister may pay all or part of the facility costs or other operating costs of an integrated community health services center, while Section 29 sub 2 allows the minister to pay any other prescribed costs of the center. Once a center has been licensed, the minister may, pursuant to Section 32, refuse to pay a claim for payment for a service rendered in whole or in part if the minister is of the opinion that all or part of the service was not in fact rendered, if it was not rendered in accordance with the requirements of the Act, or there is an absence of the required record of service. The minister may also recover money that, in the opinion of the minister, a licensee owes to the minister by any method, including, but not being limited to, a set-off against any money payable to them under the Act. Finally, Section 42 sub 1 allows the minister or the director to appoint inspectors for the purpose of ensuring compliance with the Act. So it's very clear that the Act provides the minister with significant powers and that monitoring of licensees is going to be taken very seriously. So with that said, I'm now very pleased to call upon my colleague, Laurie Turner, who is going to provide an overview of the issues relating to the operation of an integrated community health services center. So Laurie, please go ahead.
Great, thanks, Christine. Sorry about that. I'm glad to speak to you today to provide an overview of the Independent Health Facilities Act and the Integrated Community Health Services Center Act, and particularly as they relate to operations of independent health facilities. So, as you may be aware, the current regime that is in place to govern independent health facilities is the Independent Health Facilities Act. And I'll be referring to that as the current act in this presentation. Next, please. And as you likely know, Bill 60 was recently introduced, and that bill is referred to as your Health Act. That bill recently passed its second reading and has now been referred to a committee for its review. And next. So if Bill 60 is passed, among other things, Bill 60 will revoke the Independent Health Facilities Act, and it will also implement or enact the Integrated Community Health Services Center Act, which, because of it being a mouthful, I'm going to refer to simply as the proposed act. Great. Next slide, please. So at a very high level, the proposed act is very similar to the current act in the sense that it establishes a licensing, payment, quality assurance, and inspection regime that's applicable to integrated community health services centers, which again, given the lengthy name, I'm going to refer to as centers. And it also prohibits persons other than centers from charging or receiving payment for what are called facility costs. And so, as you'll see here, that you'll notice the difference in terminology in the proposed act than it is in the current act. So most significantly, what we refer to currently as independent health facilities in the current act, we are now referring to in the proposed act as these integrated community health services centers. And second, the terminology is distinct in the sense that the proposed act refers to charges or payments for facility costs, and these are referred to in the current act as facility fees. And one thing I just wanted to mention quickly is that I know Christine had provided a bit of a brief overview of the motivations behind the introduction of this act. But one thing I did want to note in particular is that the The current act, or the proposed act, is actually quite similar to the current act. Many of the key definitions, prohibitions, and restrictions under the current act are essentially the same as they are in the proposed act. But in drafting the proposed act, the government has made slight amendments to provisions which reflect its emphasis on integration, improve access, and patient experience. So the proposed act defines centers in a very similar way to how that term, or how the term IHFs is defined in the current act. So in summary, the proposed act defines center to be a health facility in which the public receives health services for or in respect of which facility costs are charged or paid, or a health facility that's prescribed in the regulations. And the notable distinction between the definition of centers in the proposed act and the definition of IHFs in the current act is the inclusion of a specific reference to community surgical and diagnostic centers as an example of the types of health facilities that are captured within this definition. However, that's not to mean that community surgical and diagnostic centers are not already operating within the current legal framework for IHFs. We know very much that they are. So I think, again, that this just, the inclusion of this language just, again, relates back to the government's emphasis on increasing access to care and patient experience in terms of wait lines and that sort of thing. Next slide, please. So you might be wondering at this point why these terms are important in terms of facility fees and facility costs. So both acts prohibit anyone other than an IHF in the case of the current act, and centers in the case of the proposed act, from charging or receiving a payment for a facility fee and a facility cost. These terms have very similar definitions under the current act and the proposed act. So both definitions are a charge, fee, or payment that is for in respect of a service or an operating cost that supports, assists, and is necessary adjunct or one of them to an insured service and is not part of the insured service. So what charges, fees, and payments are exempt from that? Regulation 650 to the current act establishes certain charges, payments, and fees that are not a facility fee. So for instance, the cost of drugs that are used to promote ovulation, and annual physicals that are performed in whole or in part to complete a document for admission to a school. And because the regulations to the new act have not been tabled at this time, it's not clear whether or not the regulations to the new act will exempt the same types of charges, fees, and payments, but we expect that it will be the same under the new act. So again, you might be questioning my last statement, thinking, how then do dental, chiropractor, and other clinics who are not currently licensed as independent health facilities keep the lights on without being permitted to charge overhead fees? So there's a few reasons for that. First, the prohibition that's applicable to facility fees and facility costs only arise in the context of an OHIP insured service, as the definition of the terms facility fees and facility costs are tied to the provision of an insured service. What that means is that if a clinic, such as a chiropractic clinic, is not providing any insured services, then they're free to recover their operating costs as part of the fees that they are charging to a patient, in accordance with any college rules, of course. And second, the current act exempts certain services, people, places, and facilities from the application of its act and its regulations. The regulations currently, under the current act, exempt the services of a number of health professionals, such as chiropractors and dentists. And in addition to the types of services of professionals that are exempted from the act, certain facilities, including hospitals and long-term care homes, are also exempted in the regulations under the current act. But again, because the regulations to the proposed act haven't yet been tabled, we can't say with certainty that the same exceptions will apply. But we don't have any reason to think that they won't be, for two reasons. So first, the proposed act does contemplate regulations being made to exempt services, people, places, etc., from the application of the act and its regulations. And second, there's been no indication that the government is seeking to broaden the scope of the application of the act as it relates to hospitals, professional services, etc. Next slide, please. Thanks. So in terms of significant provisions of the proposed act, as I mentioned a bit earlier, a lot of the provisions of the proposed act are very similar to the provisions of the current act. And I'm going to focus in the next few slides on the provisions of the proposed act, but where a provision of the proposed acts departs from a provision of the current act, I've highlighted it in red. And again, when I say that it departs from the current act, we know that we only have the proposed act and not any regulations there too. And we also aren't aware exactly of how the provisions of the new act are going to be applied. So it might be the case that what we see right now as a distinction isn't ultimately a distinction. So in terms of the obligations of licensees of centers, like the current act, the proposed act imposes many obligations on licensees of centers. Well, we're not going to have time to discuss all of the obligations today. I'm going to highlight some of the more important ones. So the first is to maintain records in accordance with the proposed act. And that includes maintaining records that evidence that a service is medically necessary or therapeutically necessary. And remembering that services that are provided in the clinic will be insured services, and that insured services are only payable by OHIP and prescribed circumstances such as where it is medically necessary. It's not surprising that there's a requirement for licensees to maintain records to evidence the basis upon which the provision or the service was provided. Second is a requirement for the licensees to comply with all applicable quality and safety standards, which we'll discuss a little bit later. Third, to report incidents to the director. And the term incidents is defined very broadly by the act, like it is by the proposed act, like it is by the current act, to be any unintended event that occurs where a patient receives a service at the center that leads to their death, serious disability, injury, or harm, and that isn't a primary result of their underlying condition or doesn't arise from a known risk that is inherent in providing the services. So another obligation of licensees of the centers is, of course, to comply with the proposed act and all other acts. And finally, as we'll talk about a little bit later as well, a licensee is required to produce documents and records that are requested by an inspector, and also to cooperate with the inspections. So turning now to potential obligations, continuing with potential obligations of licensees of centers under the new act. I say potential because the current act and its regulations set out the following obligations. And while they're not currently enshrined within the new act itself, we suspect that given their presence in the current act in the sense that it contemplates regulations being made to that effect, we think that similar obligations will be set out either in regulations to the new act once it's introduced, or the proposed act once it's in, or the regulations once those regulations are introduced, or in policies that are applicable to centers. So the first is to establish a method of monitoring care and treatment provided in the independent health facility. And then other obligations relate to quality assessment. Under the current regime, under the Independent Health Facilities Act, practice parameters and facility standards for each type of IHF has been developed by the College of Physicians and Surgeons in respect of those services that are provided at IHFs by physicians. And then also in the case of services provided by midwives at the very few, I think it's two IHFs that provide midwifery services. It's the College of Midwives that sets those practice parameters and facility standards for those IHFs. Licensees are also required to participate in an assessment of the facility on a periodic basis. Under the current act, that period is 5 years. And again, the College of Physicians and Surgeons in respect to facilities where physician services are being performed, and the College of Midwives in respect to facilities where midwifery services are being performed, are given the power under the current regime to appoint the assessors for facilities. So again, it's unclear exactly whether or not those colleges will continue to have those powers under the new framework. That's to be seen. So, sorry, if you can go to the next slide, please. Great, thank you. So, turning to restrictions that are applicable to licensees of centers, under the proposed act, very similar to the current act, licensees can't transfer a license without the consent of a director, or engage in any sort of transaction where they are transferring their shares of a corporate licensee. So that means that if you acquire a license and you later want to transfer that license to a different entity, for instance, or if you want to sell the shares of the entity that owns that license, you need the consent of the director. And also, licensees are restricted from using the license as a security for the payment or performance of an obligation. And any security that is granted is void. So that means, for instance, that a licensee that enters into a general security agreement in the context of a lease, for example, to the extent, of course, that the license itself isn't excluded from the scope of that application or from the scope of that agreement, that would be void. Next slide, please. So with respect to some of the powers of the director under the Act, under the proposed Act, again, very similar to the current Act, the director has the power to amend limitations or conditions on a license, and that includes to add or remove services. But the addition or removal of services, and in particular, the removal of services, is subject to stated limitations and conditions. Meaning that the director can't just yank services from your license so that you're not able to provide those services anymore for no reason. Directors are also allowed to refuse to renew a license. And when refusing to renew a license or determining whether or not to refuse to renew a license, the director is required to apply the same considerations as they do when they're determining whether or not to grant a new license, and those sorts of considerations Lynne will speak about in her presentation. And also the right to revoke or suspend a license where a licensee is in breach of the Act or where the center is not being operated in accordance with safety standards. The other interesting and significant point of the Act, which again is a carryover from the current Act, is that there's no due diligence defense available. So that means that the fact that a licensee was diligent in an attempt to comply with the law will not be accepted as a defense to prevent the right of a director to, for example, revoke a license in the event of non-compliance. So turning next to powers of inspectors and inspecting bodies. The powers of inspectors and inspecting bodies likewise reflect those in the current Act. The minister or the director has the right to appoint inspectors to confirm compliance by a center with the Act and its regulations. And the inspector can, subject to a limitation I'll discuss in the next slide, enter into a center at a reasonable time, or any other place where records related to the center's operations are maintained. The inspector has a right to request a large scope of documents and information, and they also may bring in an expert to the center to assist in making a determination. So for instance, an inspector may bring in an assessor who's been appointed under the Health Insurance Act to help them determine whether or not the facility or the center is providing medically necessary services as such are defined within the Health Insurance Act. And as I noted earlier, licensees are required to cooperate with inspectors and to provide documentation and information when they are requested. Next, please. However, the powers of the inspectors are not absolute, and neither are the director's powers. So for instance, in respect of inspections, if any part of an IHF is used as a dwelling, meaning a place where a person resides, an inspector can't enter that place without the occupier's consent, and they also can't use force to enter into a center. Also notable is the fact that the proposed act, like the new act, includes a process that applies where a director refuses to renew a license or revoke a license, for instance. And in that case, licensees are entitled to a hearing by the Health Services Appeal and Review Board, and also to appeal the decision of the board to the divisional court. Next slide, please. So in terms of responsibilities of inspecting bodies under the proposed act, I'm not going to go through all of them, but a few of those responsibilities include establishing a schedule for routine inspections of centers, establishing, maintaining, and publishing quality and safety standards for centers. And as I noted earlier, currently that role falls to the College of Physicians and Surgeons and the College of Midwives of Ontario. And also submitting reports of inspections, making compliance orders, and then also making those reports and the compliance orders public, but after the inspecting body removes any personal health information from the details of that report or that order. In terms of some other matters at a very high level, in terms of funding, so it's not entirely clear what the funding framework will be under the proposed act. But as I noted earlier, the current funding regime for IHFs generally is that physicians who are providing the services at an IHF are entitled to receive professional fees for such services, with the amount of those fees set out in the OHIP schedule of benefits for physician services. And in respect of those services that are funded by OHIP, meaning those services that the ministry has agreed to make funding available to an IHF, the IHF is entitled to receive the facility fee for that service or for the services it offers that are set out in the OHIP schedule of benefits for independent health facilities. And IHFs might also be funded under funding agreements with the ministry. And it's notable that while physicians providing services at IHFs are always entitled to receive the professional fees for the services that they render, they're contingent, of course, upon them meeting the conditions for payment under the OHIP schedule of benefits for physician services. It's not always the case that an IHF license will have funding attached to it, in the sense that it's not always the case that an IHF will be able to bill facility fees in respect of services that it offers. In that case, as you can imagine, relying on only the fees that are payable to a physician for the entire operating cost, including the payment to physicians, the payment to staff, keeping the lights on and so forth, is just not something that people can make work. It's just not enough money. So it leads to a very difficult situation. So again, the ability to bill the government for those facility fees is something that's really important. And again, it remains to be seen whether or not those funding models will be used going forward. And finally, just a few other minor notes with respect to offenses. The offense provisions of the current act are generally carried over to the proposed act. So for example, it's an offense for anyone to obstruct an inspector. And penalties for individuals are of fines not more than $50,000 per day. But interestingly, these fines are per day that the offense occurs. So if it occurs for 4 days, the fine cannot be more than $200,000. And there's also a potential imprisonment of up to 12 months. And those fines increase up to $100,000 a day for subsequent offenses. And likewise, the Act sets out penalties for corporations. The fine is $100,000 a day being counted per day of the offense and up to $500,000 for subsequent offenses. And again, there's no due diligence defense available in respect of these offenses. And finally, I just want to note that, as I mentioned at the outset, and I've mentioned a few times throughout, the regulations to the proposed act have not yet been tabled. So again, it remains to be seen whether or not the provisions that are absent from the current act, that are included in the current act, but not yet included into the proposed act or the new legal framework will be carried over into those regulations, and how much of an impact those regulations will have on helping us interpret what the intent of the government is going forward.
Hi, I'm Lynne Golding, and I'm going to be speaking to you about the application process for a license under the new act. We can go to the next slide, please. So I want to be very clear that these are going to be practical comments that I'm giving to you here with a view to those who are looking to submit applications for licenses for a surgical center or a diagnostic imaging center over the next couple of years. So I'm going to really try and focus just on that. And in creating this presentation, I've drawn from a few sources: the proposed act, the current act. I've looked at a couple of calls. These are like RFPs. We're going to talk about them in a minute, that have been issued over the past decade relating to cataract surgery. So there was a call issued in 2014. No actual licenses were issued under that call, but many people made submissions. Also, there was a call for cataract surgeries in 2021 in January, and awards were issued under that application process. They were just awarded earlier this year. I'm also going to draw from the application guidelines from these two call processes. Now, what I clearly don't have, and what Laurie has already said, is we don't have the actual final act, which may elucidate on some of this. We don't have an actual application form for these new licenses, and we don't have the application guide that goes with these applications. So what I'm saying to you has to be taken with a little bit of grain of salt, but I think you'll find it very helpful as you get prepared for what will eventually be introduced. So we can go to the next slide, please. The starting point, of course, is to put your team together. I'm going to assume in this presentation that all of the applicants are corporations. You'll have a board of directors, therefore. So you need to get your board together. You need to start creating your senior leadership team, both administrative and clinical leaders. And you're going to need a bunch of consultants. You need people to help you with the clinical aspects of the application, the finance, real estate. If you don't already have your premises, you probably need to be engaging a real estate agent to help you with that. Naturally, you need lawyers. And then, of course, you will need architects or others who are going to help you with the layout of the premises. You're going to have to describe all of that. And if you're doing a new build, you're probably going to need a professional that actually has healthcare facility planning and design experience. Not just anybody can prepare the layouts that will be required by the ministry for these clinics. We can go to the next slide, please. Now, you can tell I've used the word call. In other sectors, you might hear the word RFP or proposals, but here they're called calls. As Christine said earlier, it is the minister who will decide when the time is right to issue a call, and the minister will direct the director under the Act to set it out. The call will describe what services are being sought: hips, knees, ankles, wrists, MRI, CT, whatever it may be. And they will describe the locality for which the centers will be located. We did receive a question prior to our seminar about, how there could be any certainty that there would be a center established in a small community in Ontario. So there cannot be any certainty on that, but you should, at this point, if that is something where you see a need, should be speaking to your MPP and Ontario Health and other people about how you think that the call should apply to your region. The call will set out the final date for submissions, and we're going to talk about that a little bit later, and other things that the director thinks are relevant. Next slide, please. Now, there are some limitations you need to be aware of. The director does not need to issue a license to any person. You could go through this whole process like people did in 2014, where you spend tens of thousands of dollars putting together your application, and then you could wait and wait and wait, and no awards could be made. So that is what happened in 2014. The director will have a scoring system, which will be very similar to an RFP from that perspective. So some people are going to get awards, if any are issued, and some may not. You should note that there are limitations on who can apply. For example, public hospitals cannot apply for these licenses, long-term care homes, and there are limitations on where these can be located. Laurie went through some of those. We go to the next slide, please. You should know that your application could be disqualified even before it gets through the whole evaluation process. So if in the course of reviewing the application, it's determined that there is false, misleading, or incomplete information, your application could be disqualified. It could be disqualified if it is revealed that there is a conflict of interest. Now, just keep in mind that the government's definition of conflict of interest is much broader than the definition that we use in the private sector. Government is concerned not only about actual conflicts of interest, but about perceived conflicts of interest. So you're going to want to have a real careful eye to this when you're putting together your team and their relationships with the other people that you will be dealing with when you put together your application. You're at a point right now where you're trying to gather as much information as you can about this process so you will be prepared. But there's a point at which you need to stop. You can be disqualified if it is found out that you have knowledge about the assessment, evaluation, and scoring system, how you're doing in that process. You shouldn't be asking those questions because you could be disqualified if you know about that. In addition, you could be disqualified if you attempt to influence any of the government people involved directly or indirectly in this process. So the call document will likely set out a list of who you cannot speak to about it. It'll include your MPPs, the Minister of Health, the Premier's office, Cabinet office, and any of their staff. If you have lobbyists that are engaged right now, they need to understand that there will be a point at which they cannot talk to anybody in government about your application. And finally, you could be disqualified if you have been involved in collusion. Now, what the government is getting at here is that they want as many proposals as possible. They don't want you talking to people in a way that will discourage people from applying or that will make common all of your applications so that there's really no choice to be made by the government. And you should know that collusion and bid rigging, when it comes to RFP type documents that have been issued by government, those are criminal offenses. So while you can, of course, talk to other people with the idea of creating a joint application or people joining your team, you need to be really careful about any conversations you have with people who could be competitors for the same services in the same region. Talk to your lawyer if you intend to do any of that to make sure you don't get offside the law there. So we can go to the next slide, please. So in terms of who the applicants are, first of all, this act, unlike the existing act, says that any person may respond to a call. And we think that that is the government's way of saying you don't have to be a not-for-profit to submit an application. There was a time where it was contemplated that clinics of this nature could only be operated by not-for-profits. That is not mentioned in the proposed act. We think that this is why this language is there. Now, there are a lot of provisions in the act that have to do with applications where the director is able to refuse an application or even disqualify it, depending on the conduct of the applicant. And what I want to make sure you understand here is how broad the definition of applicant is for this purpose. It's not just the corporation. The director won't be just looking at what the corporation has done or not done. Not surprisingly, the corporation will be looking at all the directors and officers. That's to be expected. The director can also look at the conduct, the history, the performance of people who control the corporation. But it doesn't just stop there. The director can also have regard to any person who has an interest that affects the control of the applicant. This is a very broad group of people. We can go to the next slide, please. It includes not only people who have shareholdings that control. So we're used to saying if you have more than 50% of the shares, you'll be deemed to control it. No. Here it's 10%. Any entity that has more than 10% of the shares of the applicant, and entities that have 10% of the shares of that applicant, if it's a corporation, or if it is a group of people who through shareholdings or otherwise on their own or with associates, and associates mean your other shareholders or directors or family members, if you together can directly or indirectly have an influence over the management and policy of the corporation, you are considered part of the applicant for determining whether the conduct previously or going forward means that you're likely to be successful. So you need to be really careful about that whole group of people that is associated with you when you're submitting your application. We're going to talk about what you should do with respect to those people in a minute. So we can go to the next slide, please. I'm now going to go through what I expect will be the content of the application. And I just want to tell you my little legend here. At the top of each slide, I've got an orange box. And in that orange box is text that's actually from the proposed statute. What the proposed statute says has to be included in the application. You can imagine it's kind of general. So then I go on below it in dark text to indicate questions that were posed in prior applications, which we think are responsive to the points raised in the Act. There are many, many questions in these applications, and I have in no way tried to itemize all of them, but just some to give you an idea of what you'll have to put down to respond to what's in the statute. And then in orange, occasionally I put commentary. Now you should know that the statute, the proposed statute, sets out 9 things that must be addressed in the application, and then a 10th catch-all that says, whatever the director may require in addition. But the proposed statute also sets out 16 criteria for the director to have regard to in determining which applications will be successful. Within that 16 are some of the 9 that are listed in the application part, and then others. When you're completing the application, and it is a question and answer process, but when you're completing that application, you're going to want to have a regard to those 16 things that the director will be considering. You're going to want to make sure you address all of those in your answers. Now, I'm not going to be speaking about the employee requirements of the application. Lennie will do that in the next session. So we can go to the next slide, please. So first of all, of course, you have to identify your management team, and this will be your directors, officers, and your management team. You're going to have to provide a bunch of information about them, including, criminal history, criminal checks, those vulnerable sector security certificates. If anybody on your team is a physician, you'll have to put down their history with the CPSO, whether they have any disciplinary matters, whether they're in good standing. You'll have to itemize everyone's experience with IHFs and their work history. Now, what I've put in orange here is I think that you need to retain lawyers to help you do deep due diligence on everybody on your management team, on your board, and in that larger group of people who have influence over the control of the corporation. Through your law firm, you can do searches to see whether any of these people are bankrupt, how many liens they have against their property. You can do Dun & Bradstreet searches. All of these things that your lawyers can get because they're public, the director's office can also get. And you want to see all of that. You want to look at their social media profile, check everything to do with their social media. Everything you can get, the director can get. And you may well see when you go through some of this that some people possibly should be removed from your team. They may make your bid a lot less successful. So just be very thorough in your due diligence on everybody in that very extended team. You can go to the next slide, please. So people ask us, do we need to have our premises identified before we submit the application? And you will most certainly have to know where your premises will be. Among other things, you have to set out how many other IHFs or centers like yours are located in your catchment area. And you'll have to identify the hospitals that are also close by. You have to set out principal design features. You have to talk about how your facility will comply with all of these standards, including the CSA standards and any standards of the CPSO or whatever other accreditation standards the government may put in place. So yes, you will need your premises to be identified and really secured before you can submit an application. We go to the next slide, please. In terms of services, you'll have to have a detailed description of the services to be provided. Now, as I say, the call will indicate hips, knees, ankles, wrists, CT, MRI, but you'll have to indicate how many of those you can do, whether it's all of them, some of them, and the number of cases that you think you can do. You'll have to set out what your quality assurance program is. Now, some of this is dictated by the statute, as Laurie described, or by the accreditation agency. But I think to be successful, you're going to want to go above and beyond that. And I've put in orange here just some ideas. These are just ideas, but you likely want to talk about the policies and procedures you have in place for this. Maybe you have minimum training and experience for people who are involved in service delivery and in your internal audit process. Maybe you'll have inspections done above and beyond what is required by the Act. You'll retain some third party to do them. Maybe you'll set up a mentorship program. During COVID, as time went on the long-term care homes all had mentor relationships for infection prevention and control with hospitals. Maybe you'll set up something like that with a hospital or someone who has more experience than you do in actually performing surgeries. Those are just ideas, but I'm thinking you're going to want to go above and beyond what the Act actually requires. We can go to the next slide, please. As Laurie mentioned, you are able to perform uninsured services in these centers. Now, there are two kind of ways to get revenue from uninsured services or products. So one is that you say, we only have enough procedures with OHIP to keep our facility occupied 4 days a week. So the other 3 days a week, we're going to do plastic surgery or something like that that isn't covered by OHIP. And that is one thing you can do. Another thing you can do is upgrading of certain implants. This is certainly done quite a bit in the cataract area. And this is permitted as long as you follow the law on this. You can't require anyone to buy an upgraded lens. Within the OHIP fee package, there will be a lens provided, there will be a prosthesis provided, there will be a device provided. You cannot require people to have an upgraded one at their cost, but you can offer it. You can offer certain uninsured services, a bundle of uninsured services, but you can't make those uninsured services a condition of you providing the insured services. You cannot charge patients any more for uninsured services than the amount that you're required or you're able to get from OHIP. Now, the government is super concerned about all of this. Any of you who watched the announcements when the minister and the premier announced these new centers will know how many questions were posed about how the government would ensure that people weren't forced to pay for upgraded lenses or devices. So likely the application is going to ask you a bunch of questions about how you're going to do this. How will you make it clear to people that they don't have to pay for this? Where will you put this in writing? Will you have signs? Will you have agreements that they're entered into? And you should have agreements where it is clearly indicated that they don't have to have these upgraded devices. And the government, as they say, they know full well that they are going to wear it. If any of these centers are charging for things they shouldn't be charged, that is going to be really hard on the government. So the government is going to really be paying a lot of attention to what you're doing in this area. Okay, we can go to the next slide, please. Wait times and patient experience. So the Act says that you will include plans as to how you're going to improve patient experiences and access. Well, that means you have to know what the patient experience is right now so that you can understand how to improve it. You're going to have to address health equity needs. And this is new language. This is not in the current Act. So how you will address the needs of diverse, vulnerable, priority populations and underserviced populations. Again, to know how you'll service them, you need to know who they are. So a resource I'd recommend to you is on the Ministry of Health website, the Ontario Health website. Look for Ontario Health Teams. and Ontario Health Profiles. You'll see a map of the province. You can click on any region, open it up, and it will talk to you about the population health in your region. That is a really great starting point. Now, if any of you will be operating in a region that has been designated under the French Language Services Act, then you'll also need to address how you will provide services in French. And of course, we know that there are many communities across Ontario where large groups of people don't speak either English or French. So you want to address how you will be able to meet their linguistic needs as well. Next slide, please. You're going to need to engage with your health system partners. Who are your health system partners? Start again by going to that Ontario Health Team map. You will be able to see who the members of the Ontario Health Team are in your region. That won't be every health service provider. May not have home care on there. It may not have other IHFs on there. There will be particularly for-profit organizations that won't yet be listed on those OHT teams necessarily, but you should identify them. So I'm thinking you're going to talk to, as I say, the Ontario Health Team. There is a leadership group there. You're going to talk to family health teams, people who deliver primary care, community health centers. You want to talk to surgeons in your area, patient groups. Home care companies could be very important for the surgical centers. Talk to Ontario Health for the period of time that you can before the call is issued. And of course, talk to hospitals. You want to keep track of how you engage with them. Are you having one-on-one meetings? Are you putting a bunch of them in a room and you're having a Q&A session with them, a town hall meeting? Are you sending out surveys? However it is you are consulting with them, keep track of that. Keep track of what you learned from the process and keep track of how you incorporated that into your application. You can go to the next slide, please. So the purpose of doing all of this engagement is so that you can get to this next stage, which is talking about how your plan will integrate within the health system, how it will lead to better pathways for patients. Now, this raises a couple of interesting issues. One is that word integrate, plans to integrate with the health system. So in the Ontario health landscape, the word integrate has a meaning far beyond what you would find in the Oxford Dictionary. Basically, whenever a health service provider decides to do more things or stop doing things or transferring procedures to another entity, this all constitutes an integration for which notice has to be given to Ontario Health. And it also has implications for labor matters. So Lennie's going to speak to that. Now, in 2014, when people filled out these applications, they had to give the notice of their integration to the local health integration networks. We don't have those anymore, at least not operating in that capacity. So the good news is this notice, if it has to be submitted, is going to go to Ontario Health. And so hopefully it will be considered at the same time as your application is considered by the director. Now, the next thing is how you are going to have linkages with the local hospital. And this is a required relationship. And I have to say, it is the biggest unknown factor we have right now with respect to this application process. There's two ways that it could proceed. Let's go to the next slide, please. In 2014, in order to actually submit your application, you had to have an agreement with the hospital as to what services it would decant, how many ophthalmology services would be moved out of the hospital and into your clinic. And you couldn't submit your application unless you had a written agreement with the hospital on that front. And you had to talk about how entering into this arrangement would affect the hospital as well as your clinic. Now, I'm not aware of anyone having discussions like this yet with hospitals. And you may not need to. In 2021, if we go to the next slide, there was no requirement to say, how many cataract surgeries were going to come out of a hospital. You still had to talk about transitions of care and seamless delivery and information sharing, and surely some of that would relate to hospitals, but you didn't have to talk about how many cataract surgeries were going to come out of a hospital and into your clinic. So we don't know yet how this is going to unroll for the new applications. Either way, you need to be talking to the hospitals in your catchment area now. They may not be willing to commit, but you need to be talking to them about options. It might be the case that they have to pick one applicant. I hope not, and I don't think it'll be that way, but it's a possibility. It may be the case that the hospital will say, I'm willing to give you 30% of my cases as long as you're successful. Now, you may be saying, 30%? I can't do a business case with only 30% of your available cases. And remember, not everything is moving out of the hospitals. It's only those cases that can be done in an efficient and effective and safe way in these clinics. But all to say, you do need to start those conversations with the hospitals now. Next slide, please. Now, what the Act doesn't require is anything to do with your budget. Nothing in the Act that says you have to provide your budget, although that is required under the current Act. And I think that is because it's probably the case that they're going to tell you when they issue this call exactly how much money they're going to give you. It may be by case. Certainly in 2014, you got paid by case. Maybe the case this way. Maybe they'll give you some other sorts of operating money. But they're going to tell you what the money is, and you just have to use that money to build out your business case. Now, it's not to say that they're not going to ask for your budget. Even though the Act doesn't require it, I believe the director in the call will be asking for your budget. Because for sure they want to know that you have a way to create your leasehold improvements, buy your equipment, get everything all set up, knowing you're going to get no capital funding from the government. The Act specifically says the most they can give you is operating funding. So knowing you're going to get no capital funding, how are you going to make ends meet? They're going to want to know that there's reasonable opportunity that you're still going to be solvent 5 years out. So I think you should plan that you will be submitting that. And then my final slide is a clock, which is all to say time is ticking by. We don't know when these calls will be issued. I think it's going to be in the next couple of months. We know how big the backlog is. Every taxpayer knows about it, and Christine made the numbers very clear to us. It's going to take some time for you to complete your applications. It's going to take the director a good amount of time to review them, months, I think possibly 6 months at least to review them. And then they're going to make awards. They could do short lists where you have to give more information. So it's going to take some time before they can actually award it, and then it's going to take time for you to get up and running. So I think that means if they really want to make a dent in these cases before the next election, they're really going to have to issue this call in the next couple months. How long will you have to complete the application? In 2014, 2 months passed between when the call was issued and when the applications were due. 2 months. 2021, it was 1 month. It won't be 1 month here. The 2021 call was only issued to people who already had IHF licenses for cataracts. So I think it will be 2 or maybe 3 months. All to say, you need to start planning for this now. If you don't yet have the 2014 application and the 2014 application guideline, I suggest you get that. The guideline is full of all kinds of really great information. Some of it's dated, but most of it isn't. And it'll give you a really good idea of the sorts of things you need to be working on now in order to reply to what we expect will be the application when it is issued. So I'm going to stop there, and I'm going to turn the microphone over to Lennie, who's going to speak to you about the labor and employment issues as set out in this new proposed bill.
Thank you very much, Lynne. It's a pleasure to speak with everyone this morning about some potential labor and employment implications of Bill 60. And I just want to give everybody a heads up. I'll largely be speaking about 2 aspects. So the first aspect will be a background, but also what an application likely requires from an employment perspective. And there's some practical, but also some legal considerations to think about when you're putting together this application. And then the second aspect is going to be some potential employment and labor implications about Bill 60. And just to highlight, of course, we don't know the regulations yet, right? This isn't final legislation. We don't know the regulations, but there's some flags that I want to raise because I think they'll be important to keep in mind as you're going along and thinking about what an application looks like and this concept of integration with public hospitals and other healthcare organizations. And so just as some background, I think there's some 4 key points to talk about as we think about the employment and labor implications. we are 3 years, roughly 3 years on from the start of the COVID pandemic in March of 2020. Now, I think it's fair to say, as Christine highlighted earlier, a lot has changed in those 3 years. And the pandemic didn't cause many of the longstanding healthcare human resources issues, but it certainly exacerbated those, of course, right? We've seen extreme demands on the healthcare system over the last 3 years. We've seen many news stories about people leaving, the nursing profession, and going elsewhere because of the demands of the pandemic. It's fair to say, I think it's been very hard on the healthcare system, but it's also forced us to look at new and innovative models of how do we deliver healthcare services in the 21st century, because the COVID is here to stay, right? We're dealing with what we have to deal with today. So keep in mind, this term HHR, healthcare human resources, it's going to be a key aspect of any application, because if you turn on the news about Bill 60, one of the key questions that everybody's asking is, where are people going to come from, right? Where are we going to staff centers? How are we going to staff centers? And so that's going to be a key theme of what I talk about in my presentation this morning. As I already mentioned, right, we've seen news stories about physicians and nurses leaving their profession at a higher rate because of issues exacerbated by the pandemic. We've seen staffing shortages, which have resulted in service reductions, temporary closures, right? You've seen on the news that particularly in rural areas, hospitals are shutting down their ERs or reducing their hours, reducing operating room hours, right? Of course, we've seen temporary closures as a result of the pandemic to divert resources elsewhere in the hospital. And of course, finally, I think this is going to be something key that will be addressed in these applications is regional differences in healthcare human resources. And so Ontario is a large province. It's a diverse province. Not all areas have staffing shortages or issues to the same degree. Now, particularly up north in rural parts of Ontario, there are extreme staffing shortages in certain areas in the healthcare sector compared to, major metropolitan areas. They might have less staffing shortages. And I think this is going to be something key to keep in mind as applications are being drafted. How will regional differences be addressed? Where will staff come from? So these are all key questions to keep in mind. Next slide, please. So Laurie's already spoke about this, but I just want to highlight to everybody that there is an existing framework, right, that this is building upon. This isn't as if staffing models are being built entirely from the ground up. Of course, with the surgical centers, these are going to be somewhat new, but we already have a framework from the current legislation from which to draw from in terms of, especially with diagnostic services, a framework for staffing exists. So I just highlight this. We're not starting from scratch here. Next slide, please. You've already largely seen this preamble spoke to about by Laurie. However, I just want to highlight some certain sections of it, because as a labor and employment lawyer, when I see certain terms or words used, it raises an eyebrow, because the legislation, and especially the preamble, it talks a lot about integration. So we have connected and convenient care. We have integration with publicly funded healthcare, advancing initiatives to optimize healthcare human resources. And so in the second aspect of my presentation, I'll be talking a little bit about some concerns or potential risks that I see, because these words integrate from an employment perspective, especially where with public hospitals, which are heavily unionized, there's potential issues resulting in the transfer of bargaining rights from public hospitals to these centers. And it's early days in terms of how these are going to be structured. But when I see these words such as integrate and seamless care, things like that, it raises some labor relations risks that I think we need to be very cognizant of as we go along. Next slide, please. So back to some of the points that I had raised a few minutes ago. The government, in some comments that we've seen already about Bill 60, have indicated that there will be safeguards to prevent hospital staff being recruited by centers. Now, this is, I think, one of the most significant, what I'll say, public concerns is, we've seen, if we already have an understaffed public healthcare system, where are we going to get staff to staff additional new centers? And I think it's a valid question. And I think what potential applicants need to do is really get their thinking caps on and be creative, because when applications are being drafted, I think the government wants to be quite sure that the staffing model for a prospective center is simply, oh, well, we'll get staff from the hospital, right? Physicians and nurses and everybody else will just take from the hospital, because that's a bit of a robbing to Peter to pay Paul situation. And I don't think that's the intention with this bill. And so right away, we need to say, well, where are staff going to come from? And I'll speak to that in a few minutes. To date, we have not seen any what I'll call no poach language in Bill 60. In other words, in some media stories we've seen from some public hospital CEOs, they said we need safeguards and some no poach language, that they can't simply take physicians and nurses and from the hospital, or if a physician is going to work at a center, they also need to retain their privileges at the hospital. We haven't seen any of this to date. However, we haven't seen regulations yet. So I think as you're going along and thinking about your applications, you need to be very cognizant of this, and to say you're going to come up with some creative recruitment strategies, not simply just taking staff from public hospitals. Next slide, please. My colleague Sophie is going to speak about this in more detail, but I just wanted to highlight early on in this section is that there are some changes to the regulated health professions legislation, which would make it more seamless for folks from other provinces to simply come to Ontario and start practicing. And I just want to highlight that, because I think the government is pointing to that as a potential source of new staff, right, for these centers. But of course, Sophie will speak to that in more detail. Next slide, please. So let's talk a little bit about what Bill 60 currently says in terms of what's required from a staffing perspective in an application. So the actual legislation talks about an application requiring a detailed staffing model for the proposed center and evidence of the sustainability of that model. Now, I can say, a detailed staffing model, those blueprints, already exist for existing ORs and surgical centers. That's somewhat straightforward. Diagnostic centers, we have those staffing model frameworks. Evidence of the sustainability of the model, to me, is a little more questionable, because, these are somewhat new. Say, well, what's sustainable? That's about being able to continually recruit folks, be able to retain them. These will be going concerns for a long time. So I believe that when we see this language, evidence of the sustainability of the model, I think they're really looking for a comprehensive human resources strategy as part of this application. How will centers approach, one, recruiting people, but then retaining them? Because there is a fierce war for healthcare talent going on right now. So I also think, as I just spoke about, applications need to be extremely cognizant of the impact on the current public delivery of services. In other words, as I already said, you can't simply say, well, we're going to get people who are already working, in the public system. Obviously, I think people will come on their own accord from the public system, but there has to be alternative methods of recruitment in the application. And so under the current framework, like, there is somewhat of a blueprint. An application does require details of the professional and other staff proposed for the facility. Having looked at it, I think what the applications will look like under this bill are much more robust in terms of a healthcare human resources strategy. So keep that in mind as you go along and hear me speaking this morning. Next slide, please. So there are 4 key requirements. I'm going to focus on the first 2 when it comes to the staffing model. What an application needs to include is staff classification with rates of compensation and ranges of compensation as applicable. In other words, they want to see, okay, you have physicians, you have registered nurses, registered practical nurses, administrative staff, medical radiation technologists, anybody else that you need to run a surgical clinic or a diagnostic center, right? They want to see what those staffing models look like. They want to see how much you're proposing to pay people. Obviously, that's because the wage rates need to be competitive to attract and retain staff. Potential ranges of compensation, how will people grow and progress in their careers? Again, that speaks to the sustainability of the model. that needs to be included in the application. The second aspect of is the number of staff required for each position. So when I see this, they really do want a comprehensive staffing plan, right? They want to see that this has really been thought through, essentially does it include potential schedules? I'm not sure it's that detailed, but I think they really want to see details of, healthcare human resources planning, like a staffing model that's comprehensive, that's robust, that makes sense, that's logical. The third and fourth requirements, the model for staffing anesthesia delivery. This is largely focused, obviously, on just anesthesiologists and who are in high demand as well. So I think it has to address that. Fourth, information regarding the hospital privileges of physicians who provide services at the center. I believe what this is getting at from some public comments I've read is that the government wants to see that physicians will work across the system. So they'll continue to retain privileges at public hospitals where they might currently operate or have privileges, and also be embedded at these centers as well. So they're not just leaving the hospital to work at the center, they retain privileges across the hospitals as well. So again, speaks to that integration. Next slide, please. So just some background information, just a brief overview of what, a staffing model or classifications in a complement could look like. So for surgical centers, obviously you have physicians and surgeons, but in a typical operating room model currently at a hospital, you have registered nurses, you have registered practical nurses, personal support workers. They have different titles, but they do assist in aftercare. Potentially physiotherapists when we talk about knee and joint replacements, right? PTs being engaged immediately after. You have IPAC, infection control, critical, obviously, in an operating room. And then what kind of administrative support staff. I do think, having gone through the last 3 years with the COVID pandemic, IPAC, infection control, will be quite critical, right? Because this has taken on a whole new meaning and level of importance. I think everybody's really realized how important infection control is in our healthcare system. So that's a surgical center. When we talk about diagnostic centers, I think we do have a good staffing model, an idea of what it currently looks like, because these already do exist under the current framework. But also too, when we talk about diagnostic imaging in a public hospital as well, it's really medical radiation technologists, and of course you have the physicians who are doing the reading, but the medical rad techs are doing the imaging itself. Those are all regulated health professions, right, through the College of Medical Radiation and Imaging Technologists in Ontario. And I know from firsthand experience, these are all heavily in demand. There's only, depending on the subspecialty of medical radiation and imaging technology, we're talking about MRI versus X-ray, for instance, there's only a handful of programs in the province that are graduating folks. And so you really need to look carefully at how many of these people are graduating every year. And I think when it comes to an innovative staffing model, I think linkages with local colleges and universities who are graduating the regulated health professions are going to be key. Do you have those programs to create a pipeline from the college? Are you going to offer training and internships and placements, right? Because nurses and medical rad techs, as part of their degree and licensing process, they all need to complete internships and placements. And so if you're considering an application, I would start talking to colleges and universities that offer these programs and start to say, okay, we're going to need to get linked in with them and get some placements going, so that one, we create a pipeline, but two, we're intricately connected with the school to be able to have students in here, but also the sustainability of the model. And so as you go along with all this, key is going to be, what is your model of care, right? Because the model of care drives your staffing needs. And so this is all linked together. Next slide, please. And so just to highlight, an RN who is a surgical nurse or an RPN that's also, supporting an OR is a highly skilled professional. They're not just a regular RN, RPN, but they have what's called a certification from the Operating Room Nurses Association of Canada, or NAC. That's typically a 3 to 6 month program that has theory and practical components. I only highlight this to say, there are staffing concerns. You need to be very cognizant of this as you go along, because these are specialized nursing positions. And so think about those linkages with training programs. How are you going to develop people? How are you going to attract people? Next slide, please. And again, these are all just some general points to consider that I've really spoke to in some detail already, but some questions you need to think about in terms of your application. And that's actually not just your application, but practically to turn on the lights and actually start to run a center. How will you recruit and retain talent? What about geographic considerations depending on your location, right? Operating in a center in the GTA might be much different than rural Ontario, for example. And so those geographic considerations will have potentially significant impacts. How are you going to train and develop your staff? Okay, you've hired people. What are you going to do to continue and further their education? What does that look like? That's a significant investment. Also a ramp up period in order to be able to operate. Again, your lights go on, but what about in the 6 month prior? How soon do you hire staff? How do you onboard them? How do you ensure they're trained to your standards, the standards that are going to be required, right? Quality assurance. I have this highlighted here that centers may offer more predictable hours for staff. So in public hospitals, public hospitals do almost exclusively operate 24/7, acute care hospitals. ORs don't necessarily always operate 24/7. Most have a component that operates 24/7 or is on call 24/7, but hours could be anywhere from 5 a.m. to 11 p.m. As a center, do you offer more predictable hours to staff, right? Are you operating primarily during the days? That's attractive to a lot of people, right? Who don't necessarily want to do shift work or overnight work. So that could be a selling feature. That could be a recruitment, incentive, if you will. Also, too, start to think about your compensation model. We've just sort of cleared out of Bill 124 as of this year, but however, many hospitals were in a moderation period, right, where wages were capped at 1%. We've seen this in the news extensively over the last several years, that hospitals were having trouble retaining folks because of the wages and being capped at 1%. And so in this post-Bill 124 world, what does compensation look like? One, at a public hospital, but two, as a center, how are you going to compensate your employees? Do you match what public hospitals are paying? Do you lead? Do you lag? What sort of benefits are you offering, right? What kind of retirement matching programs? All those types of things, because compensation is going to be a key issue, I think, just in general in healthcare over the next couple of years. And then, of course, I've said this several times already, but your application will need to address concerns and questions around current healthcare human resources staffing shortages. You need to be very mindful of that. Next slide, please. Again, just to highlight compensation, you need to start thinking about models. Are you going to employ physicians? Are they going to be independent contractors, right? We don't completely know the billing model for these centers yet, so there's some outstanding questions, but you need to come up with a compensation philosophy, as I've already spoken about, for all your staff outside of physicians, right? In public hospitals, employees do enjoy, full-time employees anyways, do enjoy extended health and dental benefits, but almost all, at least part-time employees, have access to a defined benefit HOOP pension plan, which is the healthcare pension plan of Ontario. Do you try and join HOOP? Can you join HOOP? Right, those are all standing issues. What kind of incentives do you offer to employees just outside of a straight hourly wage? Next slide, please. So these are just some highlights for some staffing strategies that I've largely already spoken to about. What I do want to say is that, there are some questions that are unknown about the levels of integration, but is there opportunity for joint training programs with public hospitals, those types of things? I do think you need to think about all these items as you're going along here, not only for the application process, but also to operate a successful center. Next slide, please. So I'll spend the last 5 minutes here just talking about some what I see as risks or potential issues with labor law when we talk about Bill 60. So I think it's no surprise that healthcare is heavily unionized. The sector in general, when we talk about healthcare and social assistance, it's 54% unionized, but most public hospitals are about 85 to 90% unionized. That's really heavily unionized. We have 4 major healthcare unions in Ontario. We have the Ontario Nurses Association, the Ontario Public Service Employees Union, QPOCHU, the Ontario Council of Hospital Unions, and SEIU. So those are the 4 major unions, and they've all come out quite publicly against Bill 60 because they're also unsure what the implications are to the publicly funded system. And so next slide, please, because I'll talk about some of these considerations. So just to start with the last point, like I do think to some degree the centers will be the target of healthcare unions, although I have to say under the current framework and the current, diagnostic imaging centers that exist that I can think of, I don't think they're heavily unionized at all. So I think there's some questions around, are these going to be targets of these healthcare unions? But as I mentioned at the beginning of my presentation, one of the key sort of outstanding questions I have is with the bill talking about a high level of integration with the existing public hospital system, there are some concerns of what I'll call related employer, whether under the Labor Relations Act or PISLRT of the Public Sector Employee Labor Relations Translations Act. So next slide, please, because I'll talk about that a little more. So Bill 60 would define a center as a health service provider within the meaning of the Connecting Care Act. And so without getting into too many details of the legislation here, what I do want to say is there are potential labor relations implications to both public hospitals and centers depending on the level of integration as healthcare service providers and the healthcare service delivery model. So sharing or coordinating health services or programs or functions between 2 employers may constitute an integration. And its integration may mean that 2 employers are somewhat related as it relates to bargaining rights flowing between them. Next slide, please. So the Public Sector Labor Relations Transition Act is what guides bargaining rights flowing between organizations in the public sector. And so it was amended in 2019, and it tightened up the meaning of an integration, sort of making the definition more narrow. It was previously quite easy to prove an integration. This legislation, called PISLRT for short, applies in situations involving public sector organizations in the healthcare sector instead of normal successor rights under the Labor Relations Act. It's not entirely clear to me if it would apply to a center just based on the current bill, but this health service provider definition under the Connecting Care Act, there is some risk that it could be brought into PISLRT. I do highlight, though, even if PISLRT doesn't apply, regular labor relations legislation applies. And I'll speak about that in the next slide. And so this is, again, just a few items on PISLRT. So the definition is a lot narrower, and I don't have a ton of concerns under PISLRT itself, because I think that for an amalgamation of 2 healthcare service providers to occur, there needs to be a transfer of all or substantially all of the assets from one to another. And I don't necessarily see that occurring based on the current model we understand is going to occur under Bill 60 with these centers. So just want to highlight potential risks, but it doesn't seem like this is where a lot of the action is going to be. Next slide, please. There are still risks that, under the regular Labor Relations Act and Employment Standards Act, that the traditional related and successor employer considerations do apply. So I say bargaining rights and employment obligations could flow from public hospitals to centers depending on the level and type of integration. So there's a lot of question marks here, right? Because we don't fully know what this model looks like. And I think the story is to be written. And because the story is to be written, you need to be very cognizant as you go along to say, well, what level of integration will there be with public hospitals? Because the government will want to see integration, but you need to be mindful of the employment and labor risks with that integration and create appropriate safeguards. And so you can also see that under the Labor Relations Act, a sale of business is defined as really a transfer or any other means of disposition. So if services are being removed, for example, from a public hospital and going to a center entirely, there's risk that it could be considered a sale under the Labor Relations Act. Next slide, please. So these are just a laundry list of standard items when we talk about related employer and factors to consider. common ownership or financial control, I don't think that'll be a risk here, but common management or supervision, I do see, the third and fourth point and fifth point being an issue, interrelationship of operations, right? Associated or coordinated policies and procedures. So if a center is almost an arm of a public hospital, I see a lot more risk than if they're standalone and don't have a ton or very little integration. Next slide, please. And what I do highlight, this is largely more for public hospitals than it is for centers. But as we talk about services potentially going from public hospitals to centers, there are provisions in the central hospital collective agreements, for example, the only one I highlight here, which talks about the integration under the Connecting Care Act and all kinds of obligations that are connected to it in the collective agreement if an integration does occur. So I think public hospitals, as they're working with centers, also need to be cognizant of their labor relations obligations. Next slide, please. So just a brief summary. What you need to do and be cognizant of as you go along here is developing staffing and compensation models. You need to be cognizant of a recruitment and retention strategies. I do say centers, are likely to be a target of healthcare unions. And then finally, as I just spoke about, there are concerns and potential implications regarding integration with public hospitals. I would say there's a lot of opportunity to create a proper framework to minimize these risks as we go along. However, the story is still to be written. So that's my presentation. I want to do right now pass it over to Sophie, who will be talking about some other aspects of Bill 60. Thank you.
Thanks, Lennie. And so as Lennie had indicated, Bill 60 does do a few other things that are to some extent related to the centers in the new act, but I'll try to keep it brief so we have time to get to questions at the end related to the entire presentation. So in addition to the new proposed act, introduced by Schedule 1 of Bill 60, Bill 60 also does a few other things, including amending existing legislation. And so I'm going to address those briefly as they relate to health professions. So like the new act and the rest of Bill 60, amendments to health profession legislation contained in Bill 60 are in support of a plan that the province released called Your Health Plan for Connected and Convenient Care on February 2nd. And so that plan has 3 pillars: the right care in the right place, faster access to care, and hiring more healthcare workers. And so these are clearly not silos, and the plan does contemplate that they're connected and designed to work together. So for example, the centers were contemplated under the second pillar, which is faster access to care. But clearly, as Lennie had mentioned, where are people to provide that care going to come from? And so necessarily it will involve hiring more healthcare workers. And interestingly, discussion of these amendments and some of the amendments themselves focus on hospitals and long-term care homes, but they also mention that staff could be for other settings. And so it's clear, that those could be people who would come to work at these new centers. So next slide, please. So the amendments in Schedule 2 of Bill 60 enable the government to enact regulations that allow regulated health professionals from outside Ontario to practice in Ontario as of right, based on their qualifications in their home province or territory, rather than needing to register with the applicable regulatory college in Ontario. So all of the legislative changes that are introduced by Schedule 2 of Bill 60, similar to the new act, require regulatory amendments or new regulations. And so on their face, they don't tell us exactly what they're intended to do, but we can make some assumptions about the nature of what those regulations will say based on the background that's been provided by the province, in particular in the regulatory registry and also in the plan that was released on February 2nd. And of course, there could be additional terms and conditions in those regulations in order for these professionals to come to Ontario to practice. But the government has explained that by eliminating the need to register in Ontario, the proposed changes are to reduce the barriers to allow professionals to come to Ontario quickly and efficiently. And the intention, as I had mentioned, is to increase staffing in Ontario hospitals, long-term care homes, and potentially other settings, which is where we suspect that could be, for example, a new center or an existing center or IHF with increased capacity. And the government, in explaining these changes, has focused on professionals from other Canadian provinces and territories in explaining the amendments. And so although on the face of the amendments themselves, it's not clear that these would just be on Canadian qualified professionals, it is clear from the government's introduction of these changes that it would not be for internationally qualified professionals. So although the plan does talk about other initiatives to support internationally trained professionals from coming to Canada and qualifying for registration more quickly, these as of right amendments are focused specifically on Canadian professionals. And so these amendments take the form of exemptions from the current restrictions in applicable legislation. So shown here from the Medicine Act and the Nursing Act, generally health profession legislation prevents individuals who are not members of the applicable Ontario Professional College from using titles restricted to that profession and also from holding themselves out as qualified to practice that profession. So for an example, a person who's not a member of the Ontario College of Physicians and Surgeons of Ontario can't use the title neurosurgeon or hold themselves out as qualified to practice as a neurosurgeon in Ontario because of the restrictions in the Medicine Act. But the amendments proposed in Bill 60 to the Medicine Act, the Nursing Act, and next slide, please, the Medical Laboratory Technology Act, and the Respiratory Therapy Act will enable the government to make regulations that would exempt individuals from restrictions on using professional titles and holding themselves out as qualified to practice a profession without being registered in Ontario. So those exemptions can include conditions. Given the background that's been provided by the government, we can expect that those conditions will probably be that the individual is registered or licensed as applicable in another province or territory in Canada. And the amendments are specifically in respect of medicine, nursing, medical laboratory technology, and respiratory therapy. So Bill 60 does not include equivalent amendments for all other regulated professions in Ontario. So for example, physiotherapists or dentistry. And just going back to the changes to on the previous slide with respect to the Medicine Act. So just to note that once a previously passed amendment comes into effect, that will also include physician assistants. So next slide and the next slide. And so amendments are proposed to various pieces of other health sector legislation to support the integration of these additional non-Ontario registered professionals in the Ontario healthcare system. So the Commitment to the Future of Medicare Act, which has already been mentioned in the presentation today and restricts extra billing and queue jumping for insured services, would be amended to allow restrictions on extra billing to be extended to those persons who will be prescribed by regulation. So for example, those out of province professionals who'd be practicing in Ontario. Public Hospitals Act would also be amended to prescribe other persons as physicians who could practice then in hospitals in Ontario. And with respect to hospitals as well as other healthcare institutions, those institutions will need to consider this also in the context of their own professional staff processes. So for example, the Ontario Hospital Association has a prototype professional staff bylaw that a lot of hospitals, have used or based their own bylaws on. And that bylaw, as well as probably the bylaws of a lot of hospitals, define physicians around, being in good standing with the College of Physicians and Surgeons of Ontario. So to the extent that professionals are registered elsewhere, that'll need to be taken into consideration for those models. And then similarly, the Healing Arts Radiation Protection Act would be amended to prescribe other persons. So for example, physicians or nurse practitioners registered outside of Ontario to order x-rays in Ontario in accordance with that legislation. Next slide, please. And so as I had mentioned, the context of these amendments also talks about staffing in long-term care homes. So there's similarly amendments to the long-term care home legislation, the Fixing Long-Term Care Home Act, which would allow for the definitions of physician, registered nurse in the extended class known as nurse practitioners, or registered practical nurses to contemplate other providers who could be prescribed by regulations. And background information about these changes explains that the reason they didn't include any amendments for medical laboratory technologists or respiratory therapists is just because they're not defined in that legislation. And similarly, the amendments would extend requirements in the long-term care home legislation related to reporting abuse, neglect, and other issues to capture these additional professionals. Next slide, please. And so similarly, there's similar amendments and other amendments to some other health sector legislation, so including amendments to the Health Insurance Act, which would extend the definition of physician to mean a legally qualified medical practitioner lawfully entitled to practice medicine in the place where medical services are rendered by the physician or another prescribed person, which would presumably allow these additional professionals to be compensated through OHIP. There are also amendments proposed to the Ontario Medical Association Dues Act, which would extend the application of that act to these additional prescribed persons, which would permit the collection of OMA dues from those persons. There's amendments to the Narcotic Safety and Awareness Act, which would expand the definition of prescriber and dispenser, again, presumably for the same purpose. And there are amendments to the Gift of Life Act, which would expand the definition of physician. There's also an amendment to that act to expand the definition of tissue, which is not clear as related and might just be a convenient place for them to have included that. Next slide, please. And so Bill 60 also includes amendments to the Pharmacy Act, which don't appear to be related to bringing in out-of-province professionals. And so this is strictly related to members of the Ontario College of Pharmacists. There isn't an extension of that definition in that legislation to contemplate prescribing, pharmacists from outside of Ontario. But nonetheless, these amendments do also support the pillars under the Your Health Act plan. They would expand the scope of the practice of pharmacy to include the assessment of conditions for the purposes of providing medication therapies. And so this is in support of an earlier amendment that came into effect on January 1st that enabled pharmacists to prescribe medications for certain minor ailments. And so the intention would be that these assessments would support that prescribing ability, which has been expanded to pharmacists. And so with that, I'm going to pass it back over to Christine, so I think who will moderate the question and answer portion of the presentation.
Great. Thank you very much, Sophie. And thanks to all of you for your presentations. And we do have some time for questions. We have received some, but if you wish to submit further questions, please use the Q&A box located on the right side of your screen. So let's start with the first question that we've received, which is, the wording costs and fees is a change. Does this open the door to changing funding models for current IHFs to a global funding versus fees for service or technical fee? I'm not sure who would be best to answer that. Lynne, is that something that you could take on?
Laurie, are you going to do that?
Yeah, I could say that. Yeah, I think it's quite possible that the funding model might shift a little bit from what's generally the case under the current act with respect to professional fees being billed by the physicians under the physician scheduled benefits on the one hand, and then facility fees being billed by the facility under the scheduled benefits for independent health facilities. On the other hand, to more of a model where there's, a funding agreement in place, which sets out, funding per service. But I do note that the funding model, like a funding agreement sort of model or a global funding sort of model, is already available under the current regime. It's not as typical as the other type of bill or fee for service model, but it is available. So I think it's just something to be seen as to whether or not there's a shift to more of a global funding model as opposed to the fee for service model. Great.
Thank you very much, Laurie. Here's another question about the director. Who is the director? Is this a minister of the government or a member of the IHF business? Laurie, this may go to you as well.
Okay. So the director is a director appointed under the Act. It's not somebody who's internal to the IHF. And I did look online to see who the current director is. under the Independent Health Facilities Act, but I wasn't able to see that anywhere. So I'm not sure who the current director is, but again, it's somebody who's appointed by the minister under the act. The other thing that's interesting is that while the current act permits multiple directors to be appointed, my understanding is that there hasn't been multiple directors ever appointed for this purpose, but given the expanded scope of services that it's proposed to be offered in these facilities on a going forward basis, and also the intent to provide increased assessments of these facilities and an emphasis on patient-centered care, it's quite possible that multiple directors will be appointed.
Yeah, I would just elaborate and say, just to make it clear, these are civil servants that we're talking about. They're not political appointments. These are civil servants.
Okay, thank you both very much. Another question is, do you need to have acquired and fit out your premises before you submit your application for a license? And I think, Lynne, this would probably go to you.
I can do that one. You don't have to have it entirely fit out. I think you're going to need to have acquired it because you're going to have to say that you will have access to it. And so you're going to need to have entered into a rental agreement, a lease, or have purchased it. It doesn't need to be entirely fit out, but you're going to have to, have all of these drawings done. So you're going to have to be a fair way along in those. In the 2014 application process, they did have kind of a two-stage process. So you only had to have a certain extent of your drawings and everything done for the first process. And if you made it to the second stage, then you had to go to another level. But I do think it's fair to say that given the backlog in cases that we have right now, I expect that one of the criteria that the government will be very concerned about is how soon you can be up and running. And so I expect that applicants who have their facilities built out or nearly built out, or it's clear that they will be built out, at the appropriate period of time after the process has complete, will probably score many more points on that than someone who hasn't commenced that at all. Now, the other thing is, as part of the application process, you have to deliver an accreditation certificate. Currently, the accreditor is the CPSO, saying that your facilities are in compliance with all these standards, building code, the CPSO's own standards, IPAC standards for infection prevention and control. And you won't be able to do that, obviously, if you haven't acquired and fit out your premises. But in one of the prior calls, I noticed that it said that you didn't have to have that accreditation at the time you submitted. There was a lag period that you could submit it a little bit later. So that might be the case here. We'll have to see. Part of it really depends on whether the CPSO will be the only accreditation agent going forward. There is talk that there could be others as well. The CPSO has a limited number of resources that they can apply to all of this. And so, if they don't feel that they can handle it all on a timely basis, the government might designate some other organization as well. I should tell you too, that it's not free to have your premises accredited either by the CPSO or any other accreditation agency. They do have fees that you have to pay for that service. So hopefully that answers the question.
Thank you. Well, there still certainly are a lot of questions and clarification I think that we need from the government on a number of fronts before we're going to be able to proceed. But hopefully people are getting some answers here today. The next question is, there were not any huge changes seen with the current act to the proposed act. Why not simply make amendments to the current act? I'm not sure whether that would be Lynne or Laurie on this one.
I expect there are two reasons for this. First of all, a number of years ago, another statute was introduced to repeal the Independent Health Facilities Act. This was introduced under the Liberal government, and I think that the law is actually on the books, but it has never been put into effect. And I think that's because the government decided it wasn't going to go in that direction. I think that statute, among other things, had this not-for-profit requirement, or at least allowed that to be a requirement. So I think the government decided it's never going to implement that statute. So it was going to have to repeal it anyway. So I think that's one of the reasons. And I think the other reason is that they probably just wanted to set the stage here for a new approach to these surgeries, and thinking that it could best be accomplished with a new act rather than just renaming the old. Laurie, do you have any other thoughts on that? Or Christine, what are your political instincts on this, Christine?
Well, I think that there's certainly a need to demonstrate to people that the government takes this seriously, that they are looking for a new approach. I think maybe if you just continued with the old way of doing things, that might not be seen as the change that is necessary in order to really deal with these backlogs and wait lists. Laurie, please go ahead with your comments.
I don't have anything to add. I had a similar question, so.
Thank you. All right. Now, another question is, there are different scopes of practices for healthcare professionals across the provinces and territories. Nurse in province A may not be able to do the same things as nurse or doc in province B. Does the act contemplate which jurisdiction or regulator handles the issue?
Yeah, so I can touch on this. Just to say that, so no, it doesn't address this explicitly, neither in the amendments nor in any of the commentary from the government that I've read. That being said, the amendments are not exempting these people from the entire scope of the legislation. They're actually contemplating them by this legislation, by contemplating that they could be prescribed to be able to practice medicine within the legislation that exists in Ontario. So I would interpret that to mean that they're going to be subject to all the acts and regulations that apply to, physicians as a defined term in Ontario. So it's interesting. I mean, the legislation also doesn't address the long-term plan. So if someone permanently relocates to Ontario, at what point do they become registered with, if we're talking about physician, the CPSO, and beyond legislation, all the policies of the colleges. So I think that there are certainly some unanswered questions on that. And obviously people are limited to, their competencies and what they have experience in. But in terms of jurisdiction of what applies to them, these amendments seem to indicate that the legislation in Ontario would be applicable to someone who's practicing as a physician, prescribed by regulation in Ontario.
Great. Thank you, Sophie. Okay, the next question is, do you need to be a not-for-profit corporation to apply for a license? And I think, Lynne, that would go to you.
And the answer is no. There's nothing in this act that specifies that. And that language that says that anyone can apply, I think, is intended to address that. So there's nothing limiting the applicants to being not-for-profit.
I just wanted to add as well that, and I think Lynne made this clear as well, but in addition to there not being any sort of requirement that an entity be a for-profit or a not-for-profit, well, the legislation, like the old legislation, does contemplate the requirement that centers be operated with professionals who have the proper training, service experience, et cetera. There's likewise no requirement that, for instance, a facility that provides physician services or radiology services is owned by a radiologist. For instance, I know that there were a few associations that were potentially taking the view or maybe espousing the view that in order to apply for or to be a holder of a license providing a certain service, the applicant had to be licensed to perform those services, and that's not the case as well.
Great, thank you. All right, another question. What are the amendments to FIPA in Bill 60, and are they relevant to centers? And I think probably that will go to you, Sophie.
Yeah, so there's also a Schedule 3. So Schedule 1 is the new Act, Schedule 2 is the Health Profession Amendments and the Pharmacy Act Amendments, and then there's a Schedule 3 to Bill 60, which are amendments to FIPA, and they don't appear to us to be in any way directly related to centers. They're about provisions of FIPA or extending provisions of FIPA to what are called extra ministerial data integration units, which are organizations external to the government that handle data and will have access to data. And our understanding is if you were to be designated as one of those units, that's a pretty long process. So it's not going to be sprung on anyone, and doesn't appear to be in any way related to these centers. There is an example given by the government ICES in their regulatory registry explanation. So I think it's just a convenient place to put those amendments in this bill, but it's just amendments related to specifically those extra ministerial data integration units. And I think you would know if you were subject to those.
Terrific. Thank you, Sophie. All right, here's another one. What are the chances of success with an application for someone that has no prior licenses? Can you apply for more than one license based on locations? Not sure who would want to tackle that one. Lynne, Laurie?
I think Laurie, I'll leave you to the number of licenses per location. So can you apply if you have no experience? Anyone can apply. Anyone can apply. It is a lot of effort. It will cost you a lot of money to do a good application. So I think that you're going to only want to do this if you think that you can be successful. If you have no experience in this sector at all, you absolutely need to be joining another group of people who do have experience. I just don't see how you'll otherwise be able to complete the application in a way that would give you a chance for success.
Yeah, and in terms of whether or not the number of licenses. So I know it's the case currently that, for example, a single corporation may hold multiple licenses, so multiple IHF licenses in respective different locations. But to the extent that a single licensee, or to the extent that a corporation, for example, wants to provide various services within the same location, then they would just have a single license. There wouldn't be an additional license granted in respect of different services. So only separate licenses are required where you're operating, or a licensee is operating from two different spaces.
Great. Okay, thank you both for that. I think we have time for one other question, and I'm not sure if there's an answer for this, but the question is, are there plans to announce any more IHFs for ophthalmic services? And Lynne,
so we don't know. Yeah, we don't know who is going to, what services are going to be put out there, but we know that there continues to be a very long wait line for cataracts. So I would expect that at some point there will be more cataract services put out in a call. I think that having just released some, made an award earlier this year for new cataract procedures. I expect the next priority is going to indeed be these surgical hips, knees, wrists, ankles sorts of things. I expect that's what will be coming up next.
And I just wanted to add to that the ministry website has a section on independent health facilities, and also another section that pertains to applications or calls for applications. So there was the historical call for applications, but there's also a note that there's an upcoming potential call for applications. And within that statement, it says the types of procedures that they anticipate will be the subject of that call, and ophthalmologic procedures are not included in that.
Great, thank you. Now, I think we've come to the end of our time for questions, but if we didn't reach your questions and you would like to discuss it with us, please feel free to send an email on to us and we'd be happy to answer your specific question. But we are also going to be sending a follow-up email, which will include a copy of today's presentation and recording. It will be circulated in the next few days, so please keep an eye out for the follow-up in your inbox. This session was worth 2 hours of substantive credit, and CPD certificates will be circulated in the next few days. Please let us know how we did today and kindly complete the event survey. We'd be very grateful. We'd love to hear about the topics you would like us to present in the future. And thank you so much for joining us today. Thank you. Bye for now.